Welcome everyone to Immigration 301, Office Hours with Jeff and Danielle. This is your advanced level guide to navigating the world of immigration. We're here to break down the complexities of immigration law with practical tips, clever hacks, and real-world case studies to help you find solutions. I'm Danielle Goldman, entrepreneur, immigration advocate, and guide for innovative solutions in the immigration space.
And I'm Jeff Goldman, immigration attorney with over 30 years of experience helping individuals and companies achieve their immigration goals.
Together, we're taking your questions, tackling your challenges, and delivering the insights you need to move forward with confidence on your path. Whether you're an immigrant, an employer, an attorney, or an advocate, we've got tools and the answers you need, so let's dive in today. This week, we are going to be diving into conversations about Jeff's presentation to founders at Harvard Business School. And we've got some game-changing tips that could make all the difference for you if you're starting a company in the United States or navigating your immigration challenge related to being a founder. Plus, we're going to be answering some viewer-submitted questions about green cards and chatting about H-1B season and some hot takes about the political landscape. So stick around till the end. You won't want to miss it. Jeff, let's dive in. And I'll start by saying that the goal for this entire podcast is to really replicate the conversations that you and I are constantly having. We are on the phone all the time. We are talking, throughout the day about what conversations you're having with foreign nationals. You're answering my questions about conversations I'm having with foreign nationals and companies and others. So I'm excited to give everyone a taste of those conversations. And we were about to reflect this week on your presentation at Harvard, but I want to make sure that it's recorded because everyone's going to want to hear about it. It was so interesting that you were there as their lawyer in residence for all immigration matters. So why don't we start there? I really just want to hear all about it. What did you present on? And what were some of the main goals of the presentation?
Yeah, Danielle, it was really interesting. What everybody wanted to know right from the beginning is how do you start a company when you don't have work authorization? So this would be people on F1 status before they get OPT, or people on J1 status before they get any kind of academic training. How do you start a company? Well, there are certain things you can do legally while you're in F1 or J1 status without work authorization. You can form a company. You can file documents with any state in the United States to create a legal entity. Maybe it's a corporation or maybe it's a limited liability company. That is not a violation of your status. You can be named to the board of directors or board of managers. You can be named one of the honorary officers, such as a president, secretary, or treasurer. And you can attend board meetings, you can attend business meetings, and you can attend networking events. The reason you can do all of that without violating your status is none of those activities are productive work that violates your status. As you all know, you cannot do productive work if you don't have work authorization, but those activities are not considered to be productive work.
Just to be clear, you were there starting to talk to students about how they can actually begin building their company while they're still in school on F1. That's what you're talking about is the fact that they can actually start the entity without being on any other status. Is that right?
That's correct. Many of these students need to start their company now for so many reasons, one of which is they want to enter the H-1B lottery. And they can't do it until they have a company and an employer identification number. So you have to start a company to enter the H-1B lottery. So they're all asking, how do we do it? We're so scared of violating our status, our F1 status, and you can do it. I think what is really important to say is here's what you cannot do. Unless you have work authorization, you cannot do productive work that directly advances the services or products that your company is creating. That would be a violation of your status.
And so What were you talking about for these individuals once they do want to get into a temporary work visa or green card status? Do you advise these founders to go right for green card? Are you telling them to think about temporary work visa options? And if so, what is the best practice for these Harvard founders and frankly for any founder that's trying to get a company off the ground?
Well, most of them, their first work authorization to help launch their company will be either curricular practical training, CPT, or optional practical training, OPT, or if you're a J1, it would be called academic training. And that's when you have legal work authorization that's granted to you by your International Scholars Office. So certainly to start with, you want a conversation with your International Scholars Office. How can you get legal work authorization to work on your own startup? But many of them are talking about H-1B. As most of you know, the H-1B is limited to only 65,000 per year with an extra 20,000 for those who have at least an advanced degree from a US university. So they're very limited in number. The demand exceeds 600, 700,000 every year. So the solution is to have a lottery. That's how our government has decided to hand out the limited number of H-1Bs. The lottery is every March. It's coming up just in a few weeks. And to enter the lottery, you need an employer to enter you in the lottery. So I'm not going to get into the requirements for H-1B. I think everyone here knows that. But what's exciting is that up until 2 months ago, there was a specific requirement that there be an employer-employee relationship in order to get an H-1B. And it's been very confusing over the past numerous years as to whether a founder of a startup could have his or her own company, enter them in the H-1B lottery, or even sponsor them for an H-1B petition. 2 months ago, the Immigration Service deleted the requirement that there be a valid employer-employee relationship, and instead they replaced it with language that says entrepreneurs who start their own company can have that company sponsor them for H-1B. The only drawback is that instead of a normal 3-year approval period, if you are self-sponsoring through your own company, your approval period is 18 months, with the right to an 18-month extension, and then finally the right to a 3-year extension after that. So you get the full 6 years of H-1B. It's just broken down into smaller pieces.
That's huge. Does that mean that you're actually advising founders to go down the H-1B route, or are you saying only if if you're not yet qualified for O1? How are you advising? I'm sure everyone there wanted to hear about O1, and here you were talking about H-1B. So how did you balance that? What were you advising?
We're advising people, if possible, to enter the H-1B lottery. The cost is only $250. It is something that one can do by themselves without a lawyer, or you can hire a lawyer and pay whatever fee the lawyer's charging to help you enter the H-1B lottery. But we really think that entrepreneurs out there, or people who are afraid that they might be laid off, or they just were laid off and they don't have a new employer ready, um, we're advising all of these people to enter the H-1B lottery and give yourself a chance of winning. Now, you might qualify for O1 down the road, but what if you're denied? You'll be so frustrated that you had not entered the H-1B lottery in March when you had the chance. So we're suggesting that all of these people enter the H-1B lottery. One question came from a first-year MBA student at Harvard who said, here's the problem. I formed a company. I think I can enter myself into the H-1B lottery, but my company has no product yet, no funding, and we'll never be able to prove that we could pay the fair wage. he said, I'm thinking of not entering the lottery this year and waiting till next year, even though I know the value of entering every chance you can. I agree with his thinking. If you win the H-1B lottery, you're going to have to prove to the U.S. Immigration Service that the company can afford to pay the fair wage. There's no set documents or amount of money that need to be shown, but you do need to show enough money in the bank, maybe combined with a couple of contracts for actual work, something to give the immigration officer confidence that the company will be able to pay the fair wage.
I get this question all the time, Jeff. If you apply for the H-1B lottery and you are selected, do you have to take that slot that year? Or can you wait and take a slot in the next fiscal year?
So it's really exciting question you're asking, Danielle, because many entrepreneurs don't understand that if you win the H-1B lottery, when you file the H-1B petition with the U.S. Immigration Service, you have a choice. You can ask the Immigration Service to immediately change your status from F1 or J1 to H1B starting on October 1st, which is the first day of our next fiscal year. Or you can check a different box that asks the Immigration Service to please approve the H-1B petition, but do not change your status to H-1B on October 1st, and instead defer the start date of the H-1B to a date of your choosing, because the U.S. Immigration Service will simply notify the consulate in your home country that the H-1B was approved. And you decide when you want to go to the consulate, get an H-1B visa, and come back to the U.S. to start your 6 years of H-1B. The biggest group of people who want to defer the start date of the H-1B are people who have F1 OPT or J1 practical training. And the main reason is, F1 and J1 do not require the employer to pay the fair wage. The employer can pay you any wage that you agree upon, including nothing. If it's your own startup and you want to work for nothing, you can do that. But the H-1B absolutely requires the employer to pay at least the fair wage for the job according to the U.S. Department of Labor's salary survey. So for startups and entrepreneurs who are going to sponsor themselves for H-1B, it's huge that you can defer the start date of your H-1B. And I got a tip. I got a great tip that just happened to sadly, it happened to one of my clients, but now all of you out there can benefit from learning this. This client, he wasn't my client at the time, but he called with a terrible problem. He had won the H-1B lottery 2 years ago. He deferred the start date. His employer, which was his own company, filed the H-1B petition and asked that the consulate be notified and not to change his status. So that's exactly what happened. And he continued to work in F1 OPT all through his STEM OPT. And suddenly, when he went to get his H-1B visa at the consulate in his home country, the consulate said, well, you have been working without status for over 2 years because when you won the H-1B lottery, somehow the SEVIS system was notified that you're no longer F1 and they ended your ability to work. And this client said, oh my God, I have a work authorization document. I've been flying in and out of the United States on my F1 visa. How could this have happened? So the takeaway is, yes, you can defer your start date to when you want it to start, but you need to check in with your International Scholars Office to make sure SEVIS is reporting that you're still in F1 OPT or J1 academic training status.
Wow, so interesting. Okay, so just to recap, individuals should be qualified for H-1B at the time of putting themselves into the lottery. So they should not be putting themselves in if they don't have a company that fiscal year they could actually get an approval for an H-1B.
No, time out, time out. Got to correct something you just said, Danielle. It is true that you must be fully eligible for the H-1B, not on the day you enter the lottery, but on the day you file the H-1B petition if you win the lottery. So, two important takeaways from this tidbit. Number one, you must have at least a bachelor's degree in a specialized field, but you don't need to have it by March when you enter the lottery. You have to have it by June 30th, which is the last day to file the petition should you win the lottery. So many people are about to get a degree, maybe a bachelor's degree or a master's degree in a different field than their bachelor's degree, and that's how they're going to qualify for H-1B. So you don't have to have it to enter the lottery. You need it when you file. Same is true with the evidence to show the company has some ability to pay the fair wage. You don't need it to enter the lottery, but you'll need something by June. And frankly, you could probably even wait, because if the USCIS office is concerned about it, they'll send an RFE and ask that you show the company's ability to pay the fair wage as of October 1st.
Okay, so it is this fiscal year you have to be qualified to get your petition approved by the time your petition is submitted. And
Yes.
to this Harvard student's point, you don't want to, if your company's not yet ready to enter the lottery or to get an approval this fiscal year, then they should wait and hold off. But even if they want to extend their OPT or extend their current F1 status, they can enter the lottery, file their petition, get an approval, and then defer it. So those are options for folks going into H-1B as founders. And that's really cool that it's even more accessible now, given the rule that was published on January 17th, which changed the game a little bit for the foreseeable future, of course. Okay, so that's H-1B. Did you talk about O-1s to these folks? I'm sure everyone wanted to talk about O-1s and green cards. We both talked to a lot of founders. That's their plan A. And I love that you're telling everyone that they should be entering the lottery no matter what as a plan B. But talk about that plan A. I'm sure a lot of people listening are on that path and want to go down that path. Any tricks or thoughts on O-1 or even national interest waiver? How do you think about going green card path or O-1 path?
Yeah, well, let's start with the O-1, which is a non-immigrant visa reserved for those who are among the more extraordinary in their field, either nationally or internationally. Many of the people in the room at Harvard Business School did not realize that you don't need to prove you're the most extraordinary in the world or in the United States. It's okay if we can prove you're among the very top of your field in your home country. And you can use all sorts of evidence that you gained outside your home country in the United States or anywhere else. So that's something important for people to realize. I think a real benefit of the O-1 as opposed to H-1B is the wage requirement. The company does not need to pay the fair wage for the job. They can pay whatever you, the employee, and the company agree to. Just like H-1B, you can sponsor yourself. Your own company can sponsor yourself. And you no longer need to prove there's a valid employer-employee relationship. Also, it is true that an O-1 might be an excellent first step toward getting a green card through the extraordinary ability path. But I want people to understand that just because you have an approved O-1 does not mean it's a guarantee that you're going to get an approved EB-1A Extraordinary Ability Green Card, because there's a very different consideration that's given by the immigration officer. As I think most people realize, the O-1 requires you to prove you meet at least 3 of the 8 criteria. For the EB-1, you need to prove you meet 3 out of the 10 criteria, but in addition, you need to prove that the totality of the evidence is indicative of somebody with sustained acclaim and someone who has risen to the very top of the field. And this last review, the totality of the evidence review, is highly subjective. And there's many cases where people prove they meet 3 or 4 of the criteria for EB1A, but they're denied because the officer did not find that the totality of the evidence is strong enough.
Hmm.
So just because you have an O1 does not guarantee you that you're going to get an approved EB1A. And you don't have to be in O1 status to apply for EB1A. You can be in H-1B, and you can even be in F1 OPT or J1 practical training. I think I'd like to talk about how that works. How can you go from F1 right to green card?
We're going to talk about it in a few minutes. It's related to one of our viewers' questions, actually. So we're going to dive into that. I still feel that I'm sure a lot of folks want to understand, for O1, if you have any additional thoughts on as a student, how, and as someone that is, potentially been working in industry, right? Been working at Microsoft, been working at Google and in OPT, but they have this company they want to start or they want to go down this O1 path. What have you seen as more interesting evidence? There's the general criteria that everyone knows and has heard of time and time again, but you've done so many O1s. What is there any kind of evidence that you think is easier for folks to achieve while they're preparing these petitions or while they're in school and thinking of how to put together a really good case?
So glad you asked that question, Danielle. And the answer is yes. There's some really interesting tips I can pass on. First of all, for the criterion of whether you have played a leading or critical role for an organization of distinguished reputation, people come to me, they've been at McKinsey, they've been at Google, they've been at Microsoft, Bain, but or any company that they've been at. They try to tell me how they have played a very critical role for the very large company. But it's really hard to prove that you yourself at this stage in your career have been a game changer for the big company. And that's what the immigration office is looking for. So we break down the distinguished organization to be something lower than the big overall company. Maybe you didn't play a critical role for your university, but maybe you played a critical role for a distinguished lab at the university. And that's the distinguished organization we use. Or maybe even in your lab, you really were not a star or a standout, but there was a committee, a consortium of people that were put together by maybe some government people, some university people, and you got selected to be on that committee. And maybe you played a critical or leading role for the committee. That was a distinguished organization by itself. So we're always looking to break down the
Oh, interesting.
depth and size of the distinguished organization. One of the criterion is whether you have been the judge or referee or the reviewer of others. So the most common way people have evidence to prove this criterion is that they've been invited by an academic journal to review people's articles, and that is excellent evidence. But there's other ways where you could be a judge or reviewer of the work of other professionals. By the way, it's not helpful if you've been the judge or reviewer of students. That is not people out there in the field. But a couple of tips here would be business plan competitions. If you can be a judge or a reviewer for a distinguished business plan competition. One of my clients was really ingenious. She was able to use a connection with a venture capital company, and they appointed her to be a reviewer of business plans that were submitted to the VC for funding because she had some distinct expertise. And
Brilliant.
they weren't flooded with people looking for funding that had that unique particular expertise that my client had, but she found a VC that did need her, and they had her review 6 different business plans, and that was all she had going for her with respect to being the judge or reviewer of the work of others.
Was
And
she
we
vol-
know
was she volunteering? Does she need to get paid for that work?
she started as a volunteer. She ended up getting permission to have CPT, curricular practical training so that she could be paid for that work with the VC. And so it all worked out very well for her.
That is an awesome and very creative idea. Really cool. Those are the kinds of things that people just aren't thinking of, right? When you read about O1 criteria, everyone takes it very literally in terms of getting published and being a judge of a hackathon. That those are the key talking points that I think most attorneys are talking about when they go and have these conversations. So I'm sure there's more where that came from. We'll talk a lot more about O1s in future discussions, but I do want to move forward and transition to a few of our viewers submitted questions. So we posted on LinkedIn this week that we were doing our first podcast, and I did get a few messages, and I'm really excited because in the future, I hope to get a lot more. And Jeff, I'm sure you'll get a lot as well. We constantly are getting questions that we can't get to, but this is a great format for making sure that we're able to solve some of the problems that you're all thinking about from on a day-to-day basis. The first one came from Karthik, and it's actually quite relevant to your conversation that we were just talking about at Harvard and H-1Bs. But what do you consider the pros and cons for someone that's been laid off between different visa categories? And is starting a company and applying for H-1B a good solution for someone that's trying to reestablish themselves post layoff? Clearly didn't have that status prior.
It is definitely a viable solution and a great alternative for those who are entrepreneurial and want to try to start their own company, and those who have some financial means to start a company, because it takes some money to start a company. But if you were laid off and you were some kind of financial person, you could open your own company. If you have a degree in finance or business and you were working in a financial position, you could open your own company and do financial consulting at a high level because you have the experience and you have the right degree for H-1B.
Are you using finance as an example?
Yes.
Okay, so any degree
Any
you
degree,
you
any
could
degree
start
that
a consulting
leads,
company in that field is what you're saying.
yes. As long as the degree, of course, must lead to the position being a specialty occupation. But whether it's business, sciences, technology, you could open your own consulting company and fairly quickly, very quickly, file an H-1B. Now, this is, of course, for people who have already won the lottery. If you haven't yet won the lottery and you were working either in OPT or J1 academic training, you you can't just file an H-1B without winning the lottery, but you could partner with a cap exempt organization, which Danielle, are we going to talk about H-1B cap exempt?
I think we should definitely talk about it. I think it's relevant for individuals who have been laid off, who are looking for some type of solution and they haven't yet won the H-1B lottery, just as you're saying. So could you talk a little bit about how that is an option for folks who have been laid off, who want to start a company or even get a new job, but their OPT is expiring? I mean, it's relevant for founders in general. Maybe just talk broadly about who that is for.
Sure. So not every H-1B needs to win the lottery. There are four organizations that can always sponsor an H-1B without winning the lottery: universities, nonprofits affiliated with a university, nonprofit research organizations, and government research organizations. So any of those four employers can very quickly file an H-1B for you if you're laid off or if you're invalid status, but you're running out of OPT and you've not won the lottery. Any one of those four organizations can quickly file without winning the lottery. How does that help you? What if you have a startup? Or what if you're working for an employer you want to keep working for and you're not looking to jump to a university position? How can it help you? Well, the law states that if any of those four cap exempt organizations file an H-1B petition for you, and it's approved by USCIS, suddenly any company, from Google down to a midsize, down to your own startup, any company can file a concurrent H-1B petition without winning the lottery. Concurrent means that you have to continue working for the cap exempt organization, full-time or part-time, and part-time can be as little as 5 hours a week. Those are being approved. And then you can concurrently have a second H-1B with either Google, mid-sized company, or your startup. Now, the downside is you still have not been counted against the cap in the lottery because you haven't won the lottery. So you must continue to work at least part-time for the cap exempt organization until you no longer need the cap exempt connection to be able to legally work for your own company. That could happen by winning next year's lottery. Or maybe you suddenly are able to qualify for O1. Or maybe you suddenly have filed a green card application that finally is at the place where you're getting work authorization. Those are ways that you can stop working part-time for the cap exempt organization and be able to work full-time for the employer you want to be working for.
Amazing. So it is a possibility for folks that haven't won the lottery yet, who are trying to start a company, who need to get an H-1B outside of the lottery cycle, to potentially do this concurrently, where they get this part-time cap exempt employment and then this full-time they can work for their own company or really any US entity. And next time we chat, we'll talk more about cap exempt H-1Bs and dive into the Build Fellowship program that we started. And we'll talk a little bit about the history there. But folks who don't know, Jeff and I started a cap exempt H-1B program 7 years ago at Open Avenues Foundation. And now it's called the Build Fellowship program, which is an option for folks to explore these part-time roles in cap exempt status. And we have a lot of founders in the program, so it is totally relevant for folks who are trying to get this off the ground. I want to move on to our next question before we wrap up with some hot takes and about the political landscape. We have a question from Daniel, who is currently an OPT and was approved for a national interest waiver, which is so badass. And he has his own company and he wants to continue to work for that company. But obviously, there's a green card backlog. So it doesn't matter that he was necessarily approved right away. He has to wait for his date to become his priority date to become current. And so, can you talk about what his options are? I mean, there's a lot of folks who are applying for a green card, and in these backlogs, what do you recommend folks do during that time?
Yeah, not a lot of options. One option, which most people don't want, but it's an option, you can depart the US. You don't end your green card pathway just because you're outside the US. You can do that. And so some people find it actually worthwhile to just depart the US and open a division of their company, a subsidiary abroad, or make those international connections they've been wanting to make. But for those who want to stay in the US, not a lot of options, but you do need to have independent work authorization in order to stay in the US. You do not get the right to stay in the US or work in the US just because you have an approved national interest waiver or an approved I-140 for any category of green card, and you're stuck in the backlog. That doesn't give you the right to be here and work here. You have to have something else. H-1B is the most logical if you can win the lottery. That permits you to stay here while you're waiting for the green card. Actually, H-1B has a maximum of 6 years, but there is a way to get extensions of H-1B beyond the 6 years as long as you've timely started the green card process. Cap exempt H-1B for those who never won the lottery, but now they're stuck in this national interest waiver EB2 backlog. They could consider a cap exempt H-1B through the Build Fellowship that Danielle mentioned, or through any other cap exempt employer that you might be able to get employed by. So that's one way to stay here.
And we certainly have a lot of folks in our Build Fellowship program who are waiting for their EAD for their green card. They have approvals and that's why they're in the program. So that makes a lot of sense.
Some people qualify for O1 at this point. Many of my clients have jumped to H4 status because their spouse is H1B and has plenty of time left on H1B. and the spouse happens to have an approved I-140 as well. That
Interesting.
is what triggers the right for an H-4 spouse to get work authorization if the H-1B spouse has an approved I-140. So that's another way people are finding ways to stay here legally and work.
Amazing. Great. And I think, it's so exciting to be able to get these answers to people. I hope Daniel and Karsvik, that was helpful for you. And if there's follow-ups, please let us know. Lastly, there is so much, Jeff, that is going on day to day as it relates to immigration and the news and everything we're hearing. I know that all of the fellows in the Bill Fellowship program I'm talking to on a daily basis are concerned and aware of the fact that there's increased scrutiny, and they're nervous and they're anxious. And we want to be able to give any sort of information that you and I are hearing in our circles that we can. So I wanted to ask you what you're hearing, and I'm happy to share what I've been hearing. But if you want to start, there's definitely been a lot of chatter around some of Trump's early policies and executive orders and then announcements along the way. What are you thinking?
I can think of two that are the topic of conversation,
Okay.
uh, both in my office and in all the discussions I'm having with other immigration lawyers. So back on January 20th, the day that President Trump was sworn in, he issued an executive order directing the State Department to gather information about countries around the world that are not able to produce reliable documents. These are countries where there's tremendous amount of fraud in the documents, and he's directed the State Department to consider adding those countries to a list where there'll be a visa ban. So think about this. Let's start with Iran. Iran, for a long time, has been considered untrustworthy with their documents and has been the subject of visa bans in the past. And they would be a likely candidate for the State Department to name to a new visa ban for anybody from Iran, even if they're getting a visa outside of Iran at a U.S. consulate somewhere else. So we're very concerned about a visa ban starting maybe March 20th, which would be 60 days after the inauguration, after the date of the executive order, because the president directed the State Department to take 60 days to review this and report back. Frankly, I'm a little nervous about it because President Trump, from his past actions, could care less if he's ruining people's lives or if he's making things so difficult for U.S. companies through a visa ban. The solution should be add extra background security checks, but don't bar every single person who's qualified to work in the US from coming here.
Jeff, are you advising folks not to leave the country right now from specific countries?
We're advising folks if you're going to leave, really strongly consider being back here by March 20th.
Wow. That's
Because
really
that would be the first day. We don't know. The government has not issued any statement saying they're about to announce visa bans. But I keep wondering, why else would the president have issued this executive order on day one, giving 60 days to start coming up with a list of countries where he would impose a visa ban, unless he's thinking about a visa ban?
What else are folks talking about in your office?
Well, today, February 26th of 2025, everyone is talking about yesterday's statement from President Trump that he's going to create a new gold card. It's a version of a green card. It's permanent residency, not for people who invest through the EB-5 program and create 10 jobs, but rather for people who are going to simply give $5 million to the US government. It's buying a green card. He's convinced that this is a great thing for the US economy because he thinks all wealthy people around the world are good for the US economy. I'm not sure what I think about that. I mean, certainly there are plenty of wealthy people who are not good hombres. They're not going to be good for the US economy, and they could care less about creating jobs in the US. They just have money. And I'm not sure they even really are going to be bringing over their companies, or their money other than the 5 million. Other people tell me, well, what's wrong with that? The US government gets 5 million bucks, and who cares if these people do anything to help our country in the future? I care. I think a lot of Americans care. Is that what our immigration history is all about? Let's sell green cards to wealthy people. I'm not being so critical to say that it's a joke. It's not a joke. It is real, and it probably is going to happen. What surprised me was when I read this morning that it's not just adding this gold card for $5 million, it's replacing the entire EB-5 program. Now, that's a bit shocking because I do
Right.
think that that has proven to be somewhat successful in helping create jobs in the US.
Well, Jeff, how is that even possible? We know that the EB-5 is it's legislation, right? Congress determines the future of the EB-5 program. Do you think that it's possible that Trump is saying replace, meaning this is going to be the obvious path for anyone that's thinking of doing an EB-5? They don't even need to, Trump doesn't even technically need to get rid of the EB-5 program. It can still exist as a plausible pathway for folks, but why would a wealthy individual from anywhere around the world choose to invest if someone has that kind of money to invest, $1 million and create 10 jobs, they most likely have $5 million and are willing to do this in a much easier and less riddled with regulations pathway. Is that a fair take?
The biggest problem I see with EB-5 is that time and time again, the US government has changed their methodology of how they count jobs created. And so you could invest $1 million today, file EB-5, but by the time you really need to prove the jobs were created, which easily could be 7 years from now, how do we know how they will count jobs, whether it be the same way as it is now? So that's the real problem with EB-5. And if you have $5 million and you can just give it to the US government and not be concerned with any of this nonsense, it might be a really good deal. But you hit something right on the head, Danielle, when you said Congress needs to act. The president has no right to create a new visa category and suddenly say it's going to be active in 2 weeks, which is what he said. It's not possible. Only Congress can create new immigration pathways. And one of the big reasons is we have a limit on the number of green cards we give out every year. Only Congress can determine how many of the limit will go to this green card category or this green card category. So totally unclear how the president could possibly initiate his gold card within 2 weeks, but certainly we'll be watching.
Wild. So maybe we'll report back next week with an update. I'm sure it's going to be immediately challenged and there will be a lot of reporting done on that.
Sure.
You know, a lot of that can feel uncertain in terms of the environment we're in right now. I think it's helpful for us to end this conversation on a positive note. Things that are hopeful for us right now in the space. I'll start. I think that one of the things that is making me incredibly hopeful right now is that there are more and more champions of foreign nationals that are coming out and building. So we're seeing more innovation in the immigration space than we've ever seen, and a lot more VC funding going towards companies in this space. So that is really cool. It means that there's a lot of people out there that are going to continue to support foreign nationals despite some of that negative sentiment. What's making you hopeful right now, Jeff?
That at least as of today, things are still going well. You file immigration petitions, H1, L1, O1, they get approved. Those that should be approved are getting approved. And when the immigration officers send requests for evidence and you respond appropriately with the strong evidence that they need to see, they're getting approved. So it's not as if President Trump has declared, let's start denying everything. That is not happening. Even visas at different consulates around the world are being approved. So it keeps me optimistic that despite challenges, we're all going to survive and thrive.
And we've been through the first Trump administration together, building a very innovative program in this space. so everyone will continue to make it through the next 4 years together. And I agree with you that we will continue to at least survive and definitely build these pathways out. So thank you everyone so much for joining our office hours today. We will be back next week with more information. I will be asking Jeff some more hot takes on what's going on in the space because things change every single day. And we're here to answer your questions. So make sure to message us on LinkedIn with what you want to hear. Thank you everyone for joining. Have a great rest of your week, and we will talk to you soon.